proposed?
It's 7:30, Thursday, April 17th, 2025, and I'm calling the regular meeting of the Clawson Zoning Board of Appeals to order. Could everybody stand and have do the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Nick, could you please call the roll?
Mr. Carpenter? Here. Mr. Hildebrandt?
Here.
Mr. O'Rourke? Ms. Perkins?
Here.
Ms. Cindy Smith?
Here.
Ms. Diane Smith?
Here.
Thank you.
Okay, the next item on the agenda is the approval of the regular meeting minutes from May 16th, 2024. Those were sent to us in the packet. Are there any
I just have
comments?
one amendment that I would like to propose.
Okay.
Item number 1, call to order, list that you called the regular meeting of the Planning Commission to order.
Okay.
I believe it should say the Zoning Board of Appeals.
Okay.
But with that change, I found the rest okay, and I would make a motion to approve the minutes.
I'll second.
Okay, we have a motion and a second. Nick, could you please call the roll?
Mr. Hildebrandt?
Yes.
Ms. Perkins?
Yes.
Ms. Cindy Smith?
Yes.
Ms. Diane Smith?
Yes.
Mr. Carpenter?
Yes.
Thank you.
Okay, thank you. Motion carried. The next item on the agenda is the election of officers for 2025. And I would entertain any kind of nominations.
Madam Chair,
Go ahead.
you can go.
No, go ahead.
Madam Chair, I would like to nominate you as the chairperson again.
Okay. I'm more than willing to step down if somebody else wanted to take that role.
We like you in the role.
I concur with that. You're doing a
I would
fine
second
job.
that motion.
Okay. Nick,
Yep, for procedurally, for nominations, there's no second needed. It's a nomination. I'll state it 3 times. If there's any objections, you may object, and then I'll call the roll call.
okay, do we, should we do the chair and the vice chair at the same time?
You
Or
do
separately?
each position separately.
Okay.
Yes.
I read the three thing. Tell me how that goes.
Yeah, so if there was more than one nomination, the first individual nominated will have their vote called first. And so the reason it's called 3 times for the record is to make sure that no one else is wanting to nominate another individual for the position.
Okay, so does somebody have to,
So I'll do that as taking the
I
role.
see,
Yep.
I see, okay. Are there any other nominations? Okay,
All right, so I will do it 3 times, just procedurally want to make sure we're doing everything properly.
okay.
Ms. Perkins is nominated, Ms. Diane Smith is chair. Are there any objections? Ms. Diane Smith is nominated as chair. Any objections? Ms. Diane Smith has been nominated chair. Are there any other nominations? All right. If it's your pleasure, I will call the roll.
Okay, can you call the roll, please, Nick?
Yep. Ms. Perkins?
Yes.
Ms. Cindy Smith?
Yes.
Ms. Diane Smith?
Yes.
Mr. Carpenter?
Yes.
Mr. Hildebrandt?
Yes.
Okay, motion carried. The next election will be for a vice chair. Can I have any nominations for vice chair?
Madam Chair, I would like to nominate Ms. Cindy Smith for vice chair.
Okay. I'd be willing to step down if anybody else was interested. But I'm honored to do it if you guys need me.
You're doing a great job.
Thank
So we
you.
would like you to continue.
All right. Ms. Perkins is nominated. Ms. Cindy Smith is vice chair. Are there any other nominations? Ms. Perkins is nominated. Ms. Cindy Smith as vice chair. Are there any other nominations? And the final call. Ms. Perkins is nominated. Ms. Cindy Smith is vice chair. Are there any other nominations? All right. Good to call the roll?
Okay, yes, call the roll, please, Nick.
Ms. Diane Smith?
Yes.
Mr. Carpenter?
Yes.
Mr. Hildebrandt?
Yes.
Ms. Perkins?
Yes.
Ms. Cindy Smith?
Yes,
All right, thank you.
thank you.
Thank you, Cindy.
Thank you, everyone.
Okay, so Nick, what about the secretary? You know, I saw we didn't have one last year.
Correct.
Do we even, I read through the bylaws. Does it need to be somebody that sits on this board or because I saw Michelle Cuckoo signed him
Yes.
as secretary.
Correct. As the clerk, she's responsible for drafting and presenting the minutes. I think historically, and the bylaws traditionally have the secretary of a board as the individual who signs the minutes, who would technically do them, but that's staff's responsibility. I think it would still be good to have a secretary in name if there's ever a chance where there's a variance that's denied and ends in a lawsuit, to have someone fill that role that's there. So I would recommend filling that seat.
Okay.
And there's likely not going to be any need for it. We always hope that's the case, not to end in a lawsuit, but just if that situation does come up.
What do you mean, Nick? Sorry, Madam Chair, if I may. What do you mean if we got into a lawsuit? What
So-
would they perform? What duties would they perform?
They would also sign the ZBA minutes as well, as a testament
okay.
to the board's minutes, that it's another
Gotcha.
level of that approval confirmation.
You meant like going to court or something, and I'd be like, do not nominate me.
I'd be sitting here all night for the nominations.
Yeah.
No, it should just be as simple as that. And again, I have yet to see, and throughout Clausen's history, a really need for that to come up. But since it's in the bylaws, I think it'd be important to fill that role.
Okay. Okay. Do you have any nominations for secretary?
I will nominate Greg Hildebrand as secretary. I'm just nominating people all over the place today.
I'm happy to accept it unless anybody else wants to do it.
No, as far as I know, it's new to this board. I've sat on this board for more than 10 years and we've never had a secretary. So to have somebody step in and man the chair, I think that's great.
I mean, maybe that's something we can do, is look at the bylaws in the future. It looks like the last time they were updated was April of 2009. So I think at maybe one of our upcoming meetings where we can get together and just review it all, kind of get a refresher on that would be important. But with that said, I'll go through the 3 times for the roll call and go
Okay.
from there. Ms. Perkins has nominated Mr. Hildebrandt as secretary. Are there any other nominations? Ms. Perkins has nominated Mr. Hildebrandt as secretary. Are there any other nominations? And Ms. Perkins has nominated Mr. Hildebrandt for secretary. Are there any other nominations?
Okay, can you please call the roll, Nick?
Mr. Carpenter?
Yes.
Mr. Hildebrandt?
Yes.
Ms. Perkins?
Yes.
Ms. Cindy Smith?
Yes,
And Ms. Diane Smith?
Yes.
Thank you.
Thank you,
thank
Greg.
you.
Our first ever.
I
Yeah.
guess, yeah. I was going to say, I've been on the board for almost 9 years now, and I don't remember anybody ever being secretary. Okay.
Well, thank you for your service.
You got to figure out the role and make it happen good.
Oh, boy. Oh, boy.
Okay, the next item on the agenda is the Zoning Board of Appeals training.
So Giffords Webster provided a PowerPoint presentation for just general ZBA training. And so I will say that there are 63 slides here. Some of it will be repetitive, things that you're aware of, but more or less, we wanted to do this just as a refresher for those of you on the board, since it has been some time since we've met. Also in the packet, I included the guided development sheets for the ZBA, which I also had a printed copy at your seat for you, because we may reference that a few times throughout this. And also included was there's a variance explanation sheet from the Michigan Economic Development Corporation that was included in the packet. Just kind of provided a general overview of variances and how the process works. And when we're going through the training, we're looking to just be informal. So if you have any questions throughout, please feel free to chime in and interrupt. We can, of course, discuss any of this.
Will this be provided to us via email after
Yeah,
the
we can,
fact?
certainly.
Okay,
certainly.
thank you.
So again, we'll be covering the history and legislation of the Zoning Board of Appeals, the rules and responsibilities, meetings, and then etiquette and procedures. The Michigan Zoning Enabling Act states that local or zoning ordinances shall establish a zoning board of appeals. There's population thresholds that state the requirements, so we're above that 5,000 threshold. Therefore, we have 5 sitting members, and we also have 2 alternates slated to be on the ZBA. Now, of course, the last roughly year, 2 years, it has been the 5 of you without any alternates. Mr. O'Rourke, who couldn't be here this evening, he had something planned previously, has been nominated to sit as the one of the alternates. So there's still an open alternate position right now, and we'll come back to that in a little bit. So the ZBA establishes rules for itself with their bylaws. One member of the ZBA must be on the planning commission, which in this case is Mr. Carpenter. He's the liaison between both bodies. The terms of appointment are 3 years, staggered so they do not expire simultaneously. Vacancies filled for the remainder of the term, and they must be filled within a month. And of course, that is contingent on if we have any active applications from folks in the community. It says ZBA members may be paid per diem or reimbursed for expenses. The city does not pay any of the other boards and commissions, so I'm not sure that will change in the future. So you may have to stay in your seat a little bit longer if you want to see that. And then just another note is that the legislative body may remove ZBA members for malfeasance, misfeasance, nonfeasance after a public hearing. A little bit more on the alternates. The alternates sit as regular members of the ZBA in the absence of a regular member. If a regular member is absent from or unable to attend two or more consecutive meetings of the ZBA or for a period of more than 30 consecutive days, they may be called to serve in the place of a regular member for the purpose of reaching a decision in a case in which the regular member has abstained for reasons of conflict of interest or due to an immediate, unnotified absence of a regular member. The alternate member, having been appointed, shall serve in a case until a final decision has been made. Sorry, I'm moving some of the Zoom tabs on my laptop so I can see the entire screen. Alternate members shall have the same voting rights as a regular member of the ZBA. Whenever possible, these 2 alternates should be provided the opportunity to rotate as members of the ZBA. And I also want to note that if you do have any questions and I'm not able to answer them tonight, I'll write them down and make sure we can get an answer for you in the future from Giffords Webster. The other board that's similar to the ZBA is the Planning Commission. The Planning Commission is primarily responsible for adopting the master plan, initiates and recommends zoning ordinance legislation and any amendments to that document. They hear and decide special land uses, which are uses listed in a zoning district that are generally compatible with the purpose and intent of that district, but which warrant a more in-depth analysis prior to approval. Generally approve, deny construction, location, and character of streets, squares, parks, or other public places, buildings, and structures through the site plan process. Difference between city council. The city council establishes the zoning and land use legislation and generally serve as the final approval authority for rezonings and zoning text amendments. Generally, zoning or land use issues are presented to the city council upon recommendation from the planning commission. ZBA issues very rarely get presented to city council. The zoning board of appeals roles and responsibilities. The ZBA is a quasi-judicial body. It is an important part of due process for applicants and municipalities. Public hearings are required for all actions of the ZBA. ZBA decisions can make or break a community's planning and zoning efforts. ZBA decisions can affect the character of an area or the entire community. ZBAs need ongoing training and assistance to do their job correctly, which is what we're here doing today since we haven't met in a while. All actions of the ZBA are application-driven. Variances from the standards of the zoning ordinance, non-use variances, and variances from the sign ordinance. Interpretation of zoning ordinance text and/or map. Appeals, which includes a decision of an administrative official or body such as zoning administrator, building official, planning commission, or legislative body. Nonconformities, if authorized by the zoning ordinance. Temporary buildings and uses. Public service or public utility building variances. So the examples of non-use variances can be seen here. So these tend to be items of yard setbacks, building height, floor area, lot width or area, parking, number of trees or landscape area sizing, sign size, and similar issues of that nature. The zoning ordinance establishes criteria for granting a variance. The ZBA's analysis of the issue should be framed by these criteria. In general, the ZBA should grant few variances. Consistently granting similar variances suggests your zoning ordinance needs amendment. And so this slide pulls the standards from our zoning ordinance of the R2 single-family residential district. So for example, the minimum lot area in our R2 district is 5,500 square feet. The minimum lot width is 50 feet. The maximum building lot coverage is 35%. And so these items are in reference to the previous slide. So if there's a single-family home coming in and there's certain characteristics of their lot, they may need to seek a variance depending on their lot conditions. And so I won't read all the practical difficulties. I know you're all familiar with those, but they are printed out on your the slide from the Guide to Development. And so we'll continue talking about these throughout the presentation if you want to have those handy and be able to look at them. So non-use variances, conditions are exceptional and peculiar to the property. So the thought behind that is, how is this property different from others? What is unique about this circumstance here? The request is not based on mere convenience or financial need or circumstances. So is the variance request simply a want rather than a need, or the ability to do what similar properties can? Is raising property value or ability to attract more business the sole argument? Substantial justice will be done. Does the variance negatively affect the neighbors more than it benefits the applicant / relieves the applicant's hardship? The issue is not self-created. Did the applicant or the previous landowner create the above exceptional peculiar conditions? Did the applicant do unpermitted work and is now asking for forgiveness? Some other considerations with non-use variances. The board can impose any conditions and requirements in connection with any decision to grant a variance, as it deems reasonable to minimize any potential detrimental effects of its decision and to promote the purposes of the zoning ordinance or which justifiably arises from the circumstances of the request. Would the variance confer a special privilege? Is the variance request the minimum necessary to allow reasonable use of the property? Are there alternatives which would minimize or eliminate the need for a variance? So I just want to specifically note those last two items, is that if there is a lot of record of, say, 40 feet wide, and they're requesting a variance where they want to build within 2 feet of a setback, but they could still build what they're looking for and have a 4 foot wide setback. And so, finding what number is right for that property, and so what type of justice can be done to do that, and might be the next slide, or these next two slides kind of put a visual to that. So in this example one, the slide is conforming with no natural features. The applicant should demonstrate what conditions exist that make compliance with the setback standard unreasonable and practically difficult. So if you look at this image, you can see the proposed lot and their proposed building / home there. They have the ability to build it in the middle of the lot without any conditions of the property that would affect it. In this next example, the lot is conforming but is oddly shaped with wetland on the side. And so every lot has its own set of circumstances that can affect what's built on it. The standards that we set for the entire district or area, with the understanding that there may be a few lots that do not have the ability to meet that, which is the purpose of the Zoning Board of Appeals. The other type of variances that the ZBA will look at are sign variances. And so the following are the considerations when reviewing a sign variance. The sign will not cause confusion or mislead the public. The sign appearance is compatible with the visual character of the surrounding area, the scale and placement to the building, relationship of color to adjacent colors, dissimilarity of shape to other signs in the surround area, dissimilarity of lettering to other signs in the surrounding area. The sign is legible from its intended location. The sign's placement on the building is compatible with the building's architectural features, including the primary entrance. The sign can be viewed with comfort by pedestrians. If located on the ground, the proposed sign is outside the clear vision triangle and presents no obstruction to vehicles entering and exiting the site. The location of the sign does not obscure the establishment's interior or its merchandise. The proposed sign does not significantly depart from the applicable provisions of the chapter. The sign has no visible guy wires or cables. The proposed sign is proportional to the other features of the site and/or building. The source of illumination is hidden from view, glare is sufficiently shielded, electrical raceways are not exposed, and lighting is compatible with surrounding light sources. The signage proposed as the basis for the appeal does not result in the perpetuation of a nonconforming sign or reduces an existing nonconformity. A sign variance may further be granted in those instances in which there has been a demonstrated showing by the applicant that the particular sign sought to be approved is suitable to the community or has some value that comports with the history, development of the community, and would not, if a variance were granted, be material and conflict with the applicable regulations for the district in which the sign is located. The other items that the ZBA may review are zoning text and map interpretation items. Zoning ordinances are presumed valid. They're established for the health, safety, morals, and welfare of the public. If it is neither arbitrary nor unreasonable, advances a legitimate governmental interest. Ordinance interpretations give weight to past interpretations, keep interpretations as narrow as possible, make sure interpretations are practical as possible to enforce. As well as map interpretations, the ZBA cannot move zoning district boundaries. They'll interpret the map based on what the ordinance says about the zoning map. And the ZBA can also review minutes of Planning Commission and City Council and other records for guidance. Official interpretations of zoning ordinance text are the sole responsibility of the ZBA. Once made, the interpretations become the official standard. The interpretation guidelines are: avoid broad interpretations, consider past administrative decisions, consider history of relevant text/intent, only interpret what is requested, seek planning and legal advice as needed. If appropriate, direct applicant to seek an ordinance amendment. And most importantly, keep good records. The ZBA may also review administrative appeals. The zoning ordinance allows a person aggrieved by a decision or by an officer, department, board, or bureau of the community. The ZBA shall review the facts of the case along with the ordinance to determine whether the decision in question was made properly, and the applicant shall not provide additional information as the question is over the facts available to the decision maker. Appeals must be based on the record. The decision guidelines base all decisions on the record of the decision or action being appealed. Don't substitute ZBA's judgment for the judgment of the entity being appealed. Limit the ruling on appeal to whether the original decision constituted a breach of duty or discretionary power. Only address the appeal that is requested, and again, seek planning and legal advice as needed. And I'll just provide an example on this one, as I don't think the ZBA has seen an administrative appeal, at least that I'm aware of. And so if this building department received an application for, let's say, a new garage, and it was denied based on our interpretation of the zoning ordinance, and the applicant felt that the interpretation of the zoning ordinance was not correct, they could apply for an administrative appeal, bring the case to the ZBA, and you would make a decision on that application. When making decisions on administrative appeals, consider, was the decision being appealed made properly? Yes, uphold it by denying the appeal. No, then the ZBA must review the case based on the standards of the review in the zoning ordinance and make a decision. The ZBA may impose conditions upon rulings. They may be attached to any affirmative decision, must be reasonable, must bear a relationship to the review standards. The local unit of government must be prepared to follow up and ensure that the applicant complies with the decision. And just to touch on that a little bit more, some of the more recent appeals, ZBA cases that have been reviewed have been related to garages. And so most times the conditions ZBA states is regarding water runoff. And so when construction is underway, our building official will go out and inspect the property throughout to make sure they're maintaining their water runoff, and we will not give a final approval on the project until there's been enough time to pass to see if a storm has come through to make sure there's not significant water buildup in the area and that their gutters are not pointed to neighboring properties, items of that nature. So we do follow up to make sure all the conditions are met once a variance is approved. The Michigan Zoning Enabling Act requires decisions shall be based upon findings of fact. The facts will vary and uniquely identify to each case. Identification of landowner and location of the land, the ordinance requirements under appeal, the physical characteristics of the land, the expert reviews and analysis, public hearing testimony, and additionally, the circuit court is authorized by the act to send back any decision with insufficient record. The following are not valid reasons to grant a variance. Following the ordinance would be expensive for the applicant. There was no one present to object to the variance. The applicant already built it. You don't feel like you like that standard. We trust that the applicant will do a good job. It will look good. The applicant really needs to get started soon, and the applicant didn't know about the standard. Public Act 110 of 2006 states the Zoning Board of Appeals shall maintain a record of its proceedings, which shall be filed in the office of the city clerk of the legislative body. Variances run with the land, so keeping a good record that is easily accessible is important. And consider identifying them by parcel in a database, which we do have that on file. Check for existing variances in the property when a new development application is submitted. Moving on to the next session is the discussing meetings. Meetings of the Zoning Board of Appeals shall be held at the call of the chairperson and at other times as the Zoning Board of Appeals and its rules of procedure may specify. Generally, a typical meeting date for us, the third Thursday of each month, should be established in the rules bylaws. A quorum, which is the majority of members, must be present for a meeting to occur. In the event of canceling meetings, a regularly scheduled meeting may be canceled for lack of an agenda, provided that notice is posted at the location of the meeting no less than 18 hours before the scheduled start of the meeting. All meetings must be in compliance with the Open Meetings Act. The ZBA should conduct business according to the adopted rules. Meetings should begin on time and follow the written agenda. All comments should be directed through the chairperson. All deliberations should be in the open. Do not hold private conferences during the meeting. Express your opinions, focus on the request. Notice of the public hearing shall be published in a newspaper of general circulation in the local unit of government not less than 15 days before the meeting date. The notice must be provided to the owners of the subject property, all persons to whom real property is assessed within 300 feet of the subject property, the occupants of all structures within 300 feet of the subject property. For multi-unit structures, one occupant of each unit shall be given notice. If more than 4 units, notice may be given to the manager, owner must be posted at the primary entrance.
Hey, Nick, can we go back to the previous slide?
Yeah. About the meetings?
Yeah, the bullet point that says all comments should be directed through the chairperson. Does that mean that these guys they shouldn't engage directly with the applicant? Or what does that mean?
So all discussion is held through the chairperson, so they're speaking to you. Typically, it's one of those items where, the ZBA has a pretty good operational sense of how you operate. And so if Mr. Carpenter has a question, you're not going to object to him. I mean, you may, but historically, you're fine with them in engaging with the applicant.
Okay.
And so that's just in there to ensure that you don't have a rogue ZBA member just interjecting their thoughts as they see fit.
Okay.
Just to have some type of decency with how the board operates.
All right, sounds good.
So the OMA is a mechanism to promote government transparency. The Open Meetings Act requires that a meeting of a public body must be made open to the public. Therefore, this requires that all decisions by the public body must be made in a meeting open to the public. All meetings must be accessible to the general public with reasonable accommodations, with ample notification, and include a segment where public comments can be heard. All deliberations of a public body in quorum shall take place at a public meeting with limited exceptions. The public may make audio or video recordings of all meetings, which we do. All of our meetings are available on YouTube, live during the meeting, and also for the public afterwards. The role of the chairperson: maintain order throughout the meeting, enforce meeting procedures, ensure courtesy is maintained and that the speakers are not interrupted. Chairperson may administer oaths and compel the attendance of witnesses. I'm not quite sure what that last bullet point means, to be honest with you. We'll have to see what exactly the intent behind that one is. That's a new addition to the council chambers, the clock.
What's a cuckoo?
Yeah. I think the volume's supposed to be off. I apologize. I really hope that stops in a moment. So I'm just going to wait until that's done, if that's okay. If it's done soon.
And then there's 8 chimes.
Could have used that for the nominations. I hope there's 4.
Could that not be turned off?
The remote's over there.
I just wondered, I mean,
Now that I got up, it's...
Yeah, no, it
Yeah.
stopped, yeah.
for future
We
meetings.
added that in for public comment to maintain, which is relevant to this next slide, actually, to time the public's ability to speak, to maintain it at a 3-minute limit. So the guidelines for public hearings describe the ground rules first. Speakers must address the chairperson. Comments should be brief and to the point, suggest a 3-minute limit. Speakers must be courteous and respectful. Speakers should only address the ZBA one time. Special requests to speak a second time may be made but are not guaranteed and should only be permitted after everyone else has been heard. Open the floor to comments on the agenda. And so just kind of going back to speaking to the chairperson is when we do have variances and public is here, people tend to speak to the applicant instead of to the board. We need to make sure when they're speaking about a certain variance or topic that they're speaking to the board, not anyone else in the audience. Importantly, do not engage in debate with audience members, which is what I was just referring to. When everyone that wants to speak has spoken one time, you may close the public hearing. And once the hearing is closed, all comments should come from the ZBA. And the chairperson may grant permission to ask questions of the applicant, the representatives, or other parties with a clear interest as well. If a motion is made and seconded, all comments should refer to the motion at hand. When discussion ends, the chairperson should repeat the motion and ask for a vote. Once a vote is taken and the matter is concluded, the next agenda item should be presented. And so when it comes to the point to repeat a motion, staff will typically be jotting that down so you can just ask us to state the motion for the record, as I'm sure you're focusing on the motion at hand and not jotting down exactly what it is. So we'll be able to provide that to the
Okay.
board. One thing that we'll be adding next time for our, next time we do have a case, is on the agenda, we'll include the public participation guidelines along with the agenda. I think that's something we should be doing for all of our boards that we have not implemented yet, but I imagine we will be.
And that will be the 3-minute.
Yeah, and so just on the back of the agenda, just the general guidelines for conduct and how much time you have to speak. So that way folks are aware that to try and keep their thoughts concise and they're getting directly to the point.
Okay.
Yeah.
So just gather everybody's comments. Don't let them engage with the applicant.
Correct.
And then
Correct.
give the applicant we could or couldn't give the applicant opportunity to like respond.
During public comment, they may, and
But like after we close public comment, then we can give the option. Or
correct.
we can decide whether we want the applicant to respond to those comments that were made during public hearing. Okay.
Yes.
Okay.
And importantly, do not feel compelled to make a decision the night of the hearing if a postponement would lead to a more informed decision. The ZBA represents the interests of the entire community, not just those at the hearing. Once the hearing is closed, the public should not be involved in the discussion unless invited by the chair. Motions must include the maker of the motion, seconder, the description of the request, the action taken, whether that's approval, denial, tabling, or postponement, any conditions attached to the approval, reasons for the action taken related to the review standards, reference to staff reports as appropriate. Importantly, be sure everyone is clear on the motion before a vote, and the chairperson should entertain only one motion at a time. If a motion includes conditions, they must be reasonable, designed to protect natural resources, the health, safety, and welfare, and the social and economic well-being of users, residents, landowners, and the community, related to the valid exercise of police power, necessary to meet the intent and purpose of the ordinance. The motion should identify who is responsible to ensure conditions are implemented. There's a sample motion included, which in the presentation I send you, I'll note what page that's on. Over the last few years with ZBA cases, we've tried doing a good job on making it clear how your motions can be made, not directing you what motion to make, but if you want to make a motion in the affirmative or with conditions or denial, we'll provide you those guidelines and standards so you understand which way you want to make your motion. Minutes, agendas, and adjournment can be provided by the majority of those present. ZBA actions on cases require a majority of the membership. And moving on to etiquette and procedures. For alternate members, they may be called on when a regular member is absent, a regular member is recused due to conflict of interest, when a regular member from another body is unable to vote on an issue due to having voted on it for the other body. Alternate members act as regular members when voting. When an alternate begins a case, the alternate must see it through to the end. This may lead to situations where an alternate is present even though all regular members are also present.
So what does that last bullet point mean? So with him being on Plan Commission, that's not what it means. If he's on Plan Commission, he can't vote for it here?
No, I will get some more clarity on that because that would essentially defeat the purpose of the liaison between the Planning Commission and ZBA. Yeah,
Okay.
I'll get some feedback on that one.
Null and void.
We also haven't had that issue of alternate members. You've all been very good with your attendance, so.
Okay.
So I'll get some feedback from Giffords Webster on that one. Thank you. A member of the Zoning Board of Appeals who is also a member of the Planning Commission, we might have our answer here, I'm not sure.
Okay.
Or the legislative body shall not participate in public hearing on or vote on the same matter that the member voted on as a member of the Planning Commission or the legislative body. However, the member may consider and vote on other related matters involving the property. That doesn't really clear up the answer.
I mean, but if there were a case, it would typically come in front of the ZBA first, wouldn't it?
So the applicant has the ability to apply, to choose if they want to get their site plan first or pursue the variance first. We have a few different circumstances where there's a special land use in a district, but there's also some level of distance requirement for a certain use. And so I can reference the automobile shops on Rochester Road because we've seen two of those in 2023. And so in those cases, they elected to get a variance first and then go to the Planning Commission for site plan approval to ensure that they can get their variance.
Yeah.
We don't have a standard for which board approval you need to get first. I think there's certain cases where a site plan would make more sense or the variance would make more sense. So it's based on the applicant that we receive. But again, I still think we need to get some more clarity on how exactly this is written, because it is a little bit confusing.
Because that means that if you had voted here for those auto parts place and they had to end up coming to planning commission, you wouldn't have been able to vote.
If they came here, if
First.
they came to planning first. and
Or
then-
either
yeah.
way, actually.
Is there language like this for the planning commission?
Not that I'm aware of.
So, I don't know.
To be continued. Good thing we don't have a case
Is that
tonight.
malfeasance,
takeaway.
nonfeasance, or misfeasance?
I didn't know.
Yeah.
In serving the community in which one lives and may work, conflicts of interest may arise. If there is a remote possibility that a decision will benefit a ZBA member personally, tell fellow members about the conflict and ask to recuse yourself from consideration of the issue. If unsure as to whether to recuse yourself, consult the city attorney ahead of time. And if that is ever the case, you can connect with me and I'll make sure our attorney provides some feedback on that potential conflict of interest. If you stand to benefit financially from any outcome of a case, there is a conflict of interest and you must recuse yourself from deliberations. A recused member should not participate in discussion of an issue and consider if the conflict of interest language of the bylaws should be revised. So maybe when we bring up the bylaws again to look at those standards, we can discuss the conflict of interest language as well. Some potential conflicts are if you're the applicant, if a close relative is an applicant, a business associate is an applicant, or a close personal friend is an applicant. In no instance should ZBA members exchange emails deliberating on ZBA items in a quorum. Passive comments about subject matters, including sharing opinions between less than a quorum of members, likely do not violate OMA. However, it is best practice to not discuss ZBA matters outside of ZBA meetings. The email account you use to receive ZBA communications could be subject to FOIA requests. So each of you have a City of Clawson email, so there's no issue of getting your personal items mixed in that. And so I believe all of you should have access to your city email by now. Some additional rules for ZBA members. Visiting a site can help members better understand proposals and concerns during the review process. Recommended etiquette for site visits. Do not enter a site without written permission from the property owners. The application can be modified to grant permission. If granted permission, schedule prior to the public hearing. If a quorum of members is attending, provide public notice. Avoid commenting on the case while on site. When on site, look closely at key conditions and surroundings. Additional rules are you may be approached by media to provide comment or give an interview on a case you may be involved in. Someone may post on social media about a case you may or have heard. Before responding to an issue, ask yourself, am I able to respond? Consult the city administration before responding. And then, is responding ethical? Never provide commentary on open cases or how you or others may vote. Another recommendation is to avoid responding on social media about a case. With other media, take the time to think about how you want to respond. All talking points should be based on facts about the issue and support your key message. Avoid using jargon. Don't feel the need to fill the silence. Stick to your key messages, and don't be afraid to tell them you cannot or do not want to comment on a particular issue. Regardless of the ZBA's care in making decisions, some cases will go to litigation. Manage the city's exposure by doing the following. Follow your procedures in every case. Be consistent. Avoid conflicts of interest. Keep good records. Make strong motions that record your reasons for taking a given action. Treat all applicants the same way. And to wrap up, there's, I believe, 5 decision principles just to kind of provide a general overview of this discussion. Variances were never intended to allow property owners to avoid compliance with the zoning ordinance. The variance process was provided to recognize that not all properties had the same physical character. Variances granted with little or no justification may have the effect of encouraging others to avoid compliance with the ordinance. granting of unwarranted variances has the long-term effect of shifting zoning policy making to the ZBA and away from elected officials. And the ZBA is often the city's last line of defense in ensuring the spirit of the ordinance and long-range planning efforts, and that long-range planning efforts are represented. And that's all we got. Sorry, you guys just heard me talk for the last half hour.
You did well.
Thank you.
Yes, thank you.
And so, as I mentioned, I will certainly provide this to each of you. And I'll provide that once I get the answer about the alternate members, so we all have a little bit more clarity on that.
Okay. All right, thank you, Nick.
Thank you.
The next item on the agenda is public discussion, items not on the agenda. And noting there is nobody in the public. Any other business, Nick?
Just a brief update and staff report. The last several weeks, I've shared that there's an ZBA training hosted at Oakland County on April 29th. I did receive 2 confirmations from folks, and they have been registered for that event. That is Ms. Diane Smith and Mr. Aiden O'Rourke. So you are registered. You should have gotten an email.
I did.
Okay, you did.
Yeah.
Fantastic. So that's April 29th. I believe it starts at 5:30 at the county executive office. And so you should just be able to attend. You should have a name tag there.
Okay.
And so the next meeting we have, I'm not 100% sure we're going to have a meeting in May at this point. We don't have a case yet. But maybe after that meeting, Mr. O'Rourke and you can provide just a bit of an update on what was covered there, just to share with everyone.
Okay.
And then, since it's been a while since we've met, there's been a few updates on some variances that have been reviewed in the past. A handful of them have been approved and completed without any issues. We do have a few projects still underway, with that being the 436 through 456 West 14 Mile multifamily. If you've driven down 14 Mile recently, you've noticed that they've started framing that project, and so that project is underway. And the one case that we saw in May last year, the temporary firework tent, went well. We didn't have any issues on the city side with their operation. Unfortunately, the applicant did share that this was not his best location for selling the fireworks, and so it doesn't sound like we will get an application from him this year. There's, of course, a chance that someone else will be interested in do that, though. And other than that, I do not have any further comments, but I'm more than happy to answer any questions.
Okay. Any questions for Nick?
We have to look up this address real quick.
Okay. I think we skipped through other business and staff report and training opportunities. Any other comments before I accept a motion for adjournment?
Madam Chair, I make a motion to adjourn the meeting.
Okay. We have a-
Second.
We have a motion and a second. All in favor?
Aye.
All right. Thank you.
Thank you.
Thank you, everyone.
Thank you.
Can you, so what do I do to sign up for that?